Greetings, it's been a while, and finally I've got a new program for you that I gave some time ago but haven't seen for a while, haven't given for a while. I'm hoping that you'll enjoy it, that it will apply to some of the issues that you're facing in your intermediate or more advanced research. And I'm going to start by talking a little bit about time, place, history, society, and then the context, in other words, for the research that we're doing in the colonial era, and then give you a very precise step-by-step case study that you can dissect and think about as an example. When I was in graduate school, historians were very fond of the saying, the past is a foreign country. They do things differently there. That was a healthy reminder to students of history that we must suspend our expectations and judgments when confronting previous generations. It proves to be an apt aphorism for genealogists as well, but for a different reason. When you shift your research to another country, you suddenly confront a steep learning curve. Government is organized differently then, laws are different, and consequently, records take on different forms than you might expect. The records you encounter may be organized and arranged differently. Entire categories of sources we typically depend on may fall away, leaving us either searching for substitutes or doing without them entirely. And of course, language and customs change. But even when we aren't shifting from one country to another, we cross major frontiers in genealogy as we go backward in time. Clearly, the late 20th century is harder than the early 20th century because of privacy restrictions. When we cross into the 19th century, we typically lose our vital statistics except for marriages, depending on the jurisdiction, of course. But in every state outside New England, almost all those civil birth and death entries are lost past the 1850s. What about the challenges that African Americans face when they cross the involuntary servitude frontier into slavery from freedom? Everything changes. Everything gets much harder. Think about the challenges that all of us face at 1850 as we proceed back to the less informative census returns of 1840 and before. So we're going to discuss today another frontier, the one located at the foundation of our country in 1776. The colonial era might also be best viewed as a foreign country. The laws are different, the records are different, even the vocabulary and the handwriting can pose a challenge. My purpose here is to describe the general qualities of those differences and how they can be negotiated, first of all, and then we'll go beyond theory and talk about how I came to discover the antecedents of my Lightfoot ancestors from Montgomery County, North Carolina. I'll talk about how I determined where they came from and how I traced their lineage to my immigrant ancestor, and then beyond him to England of the mid-17th century. Along the way, I'll illustrate techniques for transcending distance and overcoming sources that are less than forthcoming, less than voluble about the past, and less than complete as well. And I hope you enjoy the journey and find some inspiration to complete similar research of your own. So let's begin with the entity that creates most of the records that we use, that is government. The biggest distinction between our pre-revolutionary government and our present government is obvious: a different sovereign authority. In post-revolutionary North Carolina, the people became sovereign through a governor elected by the legislature. The legislative representatives were elected initially by white male freeholders. The governor delegated some of his executive powers to members of the Council of State. The Secretary of State, for example, assumed the power to grant vacant land. Nevertheless, post-revolutionary governors were weak relative to their royally appointed counterparts before the revolution. They served 2-year terms. They had no veto power or lawmaking role whatsoever. The most potent function they had was as commander-in-chief of the state militia, the forerunner of the National Guard. In this role, they were custodians of public order. Also notable was their power to grant clemency. In the colonial period, by contrast, the Crown in London was sovereign over North Carolina. Earlier in that era of settlement, the Crown tended to delegate most of its authority within individual colonies to trusted associates, lords and other notables, officers of state, who then had the power to arrange and oversee governments and to grant land and collect taxes and fees. We call those people proprietors. In some cases, as in Virginia, it was a joint stock company which exercised this kind of authority. Proprietorship was a form of colonial administration that had been used in the early 17th century conquest of Ireland. It gave the monarch the ability to reward his friends and to cement loyalty while having a proxy who could exercise his power on the spot in the colony. The king could not govern directly because of the great distances involved across the Atlantic. So basically, private citizens acted for the sovereign in most colonies south of New England in the earliest period of settlement. But the proprietary aspect of colonial government faded with time as the colonies grew in population and became more restive and resistant to old world forms of hierarchy. In North Carolina, for example, a series of rebellions against delegated governors sent by the proprietors and a major Indian uprising led to direct royal administration being imposed finally in 1729. The same trend happened in many other places along the eastern seaboard, usually due to civil unrest, maladministration, or desire to enforce mercantile economic regimes, and also imperial rivalries with other European states that made monarchs a bit uneasy. There was a legislative body in each of the colonies composed of members elected by a narrow franchise of the better sort of people. But the laws they created were subject to approval by the proprietors, and later by the office the Crown set up to oversee the colony. That board that the Crown set up was called the Council of Trade and Plantations. The assembly was also heavily weighted toward coastal and tidewater areas which had been settled the longest. Inland counties were often underrepresented in the legislature well into the 19th century. Governors were stronger relative to the legislature than they would later be after the Revolution, so long as they commanded the confidence of a broad faction of the local elite. Otherwise, a governor was often pretty much on his own because troops to enforce his directives had to be raised locally. A royal governor would have to wait a long time for a backup or advice from Westminster. The isolation of the colonies and of the settlements within them is a major factor in understanding how citizens of these places must be researched. Remember that the first governments instituted in the colonies were rather primitive because populations were small when settlement began. The governor and his council often doubled as the upper chamber of the legislature and also the colony's chief judicial body. Some colonies did not have local governments until relatively late. Some government duties we would assume pertain to local authorities were carried out at a colony-wide level. So, for example, in North Carolina, though counties existed from an early point, many matters related to the estates of deceased people were handled centrally by the Secretary of State until late in the colonial era, when county governments took over most of those functions, actually the county courts. Appeals were heard in a centralized circuit court that moved around the colony throughout the year, and then later district courts covering numerous counties and precincts were established in major courthouse towns like Salisbury or Hillsborough, Newbern, Wilmington, Edenton, or Halifax to hear these intermediate appeals across a large number of counties. The governor appointed most local officials as well. In South Carolina and New Jersey, land registries were kept centrally. There was no effective county government in South Carolina until the 1780s. That meant that all the wills and deeds, for example, had to go to Charleston for registration. And guess what? Most never made it there. So the mid to late 18th century can be a kind of a dark age in the South Carolina backcountry with very little documentation beyond the original land grants and a few quitrent and jury lists. People kept their own documents and often never registered them, or if they did, 30 or 40 years later, that might happen when they finally got into the record book. So now let's talk a little bit about land and settlement patterns. The initial emphasis was to get the country populated. When it was found that America had no vast reserves of readily extractable wealth in terms of gold or gems or spices, silver or slaves, the English began to use it as a dumping ground for their wretched refuse. The poor, religious dissidents, political malcontents, and the criminal element. Of course, when I said wretched refuse, I mean as a reference to Emma Lazarus's famous poem on the Statue of Liberty, how most Americans have been characterized at some point in terms of their ancestors coming here, not meant to be derogatory in any direct sense. The land would have to be worked intensively to yield profit, and a labor force was needed. Now, these unwanted British citizens would supply that labor, according to the colonial authorities back in England. Others were induced to migrate by the prospect of land acquisition, something that was virtually impossible, even for middling folk in England. So quantities of land were offered for each person imported into the colony. Whoever imported them got a certificate verified in the local county court, which could then be exchanged for a grant of land, often 50 acres per head or person brought into the colony, provided that the recipient met certain terms. But the certificates tended to be passed from hand to hand like currency before they were actually redeemed for land, and some were never redeemed. These were called headrights. They were subject to much fraud and abuse. There are a lot of misconceptions about them. First of all, just because your ancestor is listed as a headright, it doesn't mean that he was imported in the year the headright was redeemed for land, or that he came to the place where the land grant actually lay. Many years could pass before that happened. A headright in one jurisdiction could translate into a land grant in another. Appearance in a headright list does not mean that your ancestor was an indentured servant, or that if he was a servant, he was indentured to the person who received the grant. Any person coming into the colony under his own steam could get a headright for that importation and then sell or exchange it with somebody else. And there's surely some headrights which were totally fabricated or duplicates of earlier headrights. So beware of drawing inferences. Now, in the 17th century, it was the Atlantic seaboard that got the concentration of settlement. The planters focused on navigable waterways along which they could position their farms for maximum access to overseas markets. Goods could be readily loaded and unloaded at landing places and warehouses. They then expanded up those waterways from the coast. These were the primary vectors of population movement in this era, from east to west, or sometimes from south to north up waterways. In coastal communities, connections to other ports were a source of population movement. So, for example, Long Island and New Jersey were heavily connected to New England immigrants. Some New England dissidents moved south to the Chesapeake and the Albemarle region of North Carolina, settling at the coast. Beginning in the early 18th century, second stage migration took off in some areas, particularly in the middle colonies. Overcrowding and higher land prices led to movement south along the eastern edge of the Appalachians into the interior of some underpopulated colonies like Virginia, North and South Carolina. Earlier, the menace from Native Americans had kept Piedmont settlement at bay, so the dominant migration pattern of the colonial period was along the waterways, then north to south along the wagon road and similar trails. Remember also that the colonies were strongly connected to other parts of the British Empire, so many settlers had periods of sojourn in the British West Indies. The connections between low country South Carolina and Barbados are strong, for example. Other settlers had connections to Bermuda, Antigua, or Jamaica. For North Carolina, the predominant movement vector was north to south because of all of the obstacles created by shifting inlets in the Outer Banks, those island chains that sort of blanket the coast of North Carolina, and also the frying pan shoals at the mouth of the Cape Fear that made it difficult to navigate for a good long time. Now, another aspect of colonial life that might be alien to us was the presence of an established church. modeled on Anglican administration of parishes and dioceses in England. Now, there were exceptions to this rule, but often one church tended to be dominant in each colony during the colonial era, even when there was no establishment per se. As a consequence, smaller religious factions could come under pressure. This was even true in New England and the Quaker colonies, New Jersey, Pennsylvania, Delaware. In the Anglican colonies like Virginia, Georgia, and South Carolina, everyone had to pay tithes to support the parish system and to pay for upkeep of the churches and ministers, who were usually sent out from London by the Society for the Propagation of Christian Knowledge under the Archbishop of Canterbury's authority. America never had its own bishops or church courts. In some places, the parish was one of the principal extensions of constituted authority. As in England, it was responsible for poor relief. It could identify persons charged with irregular personal conduct or family life and turn them over to the civil authority for punishment, morals offenses. In Virginia's early days, people could be fined for not attending divine service in the parish church, as in England. The vestry also organized a regular reestablishment of boundaries between individual landowners, the processioning process. In North Carolina, despite vigorous efforts to impose one, the parish system was weak to non-existent. Parishes were designated and often referred to in legal documents, but they had no functioning vestries, and there were few Anglican ministers in the colony. In fact, one notable feature of colonial life is the general absence of churches and ministers, particularly in the interior. Small sectarian groups like the Episcopalians, the Moravians, the German Lutherans and Reformed, the Quakers were the exceptions. It was only following the First Great Awakening in the mid-18th century that Methodism, the Baptists and Presbyterians, really came into their own in the colonies. And this was the period when most people first became involved in religious life. Now, socially, the colonies varied a great deal. New England was more town-centered. Even the middle colonies tended to have clustered farmsteads and a greater sense of community responsibility. In the South, great cities were nearly unheard of, aside from Charleston. Most people lived on isolated farmsteads, and the further you went into the interior, the more isolated they became. Government was weaker in these places and interfered less in the lives of ordinary citizens. That means that the records of the time can be relatively disappointing unless you're dealing with the upper echelons of society. And the other thing to remember about social organization is the emphasis on hierarchy and deference. This was a period in which birth, wealth, and education, breeding, and connections counted for a great deal. The wealthy made great fortunes and accumulated a lot of land. They often aspired to be like the aristocrats in England in everything from dress to portraiture to living arrangements to coats of arms, carriages, and servants or enslaved people. In New York, New Jersey, and Maryland in particular, smallholding farmers were relatively rare. Most landowners were large-scale proprietors, and most others were leasing from them. This makes the lesser sort far more difficult to document. The high and mighty held all the offices and passed them to their relatives and friends. They rarely married beneath their station. The inheritance system in most southern colonies, which we call primogeniture, favored older sons, leaving the remaining children to move on or face penury. Even in Pennsylvania, the oldest son got a double portion relative to the younger siblings. In fact, the inheritance laws were a prime force in the settlement of the frontier. They kept folks moving forward to find affordable land away from their place of upbringing. The laws gave supreme authority to male heads of household and rarely interposed themselves to protect women, children, or servants. In fact, servants and enslaved people were nearly non-persons. Poor people received little mercy and were often exploited by the rich. They were considered a scourge on society, to be encouraged to move on because, obviously, if they were poor, they were morally bankrupt. That was how it was seen at the time. Not just lack of fortune, but a moral deficit. It was also a society plagued by disease and violence. Death came early for many people, often with little warning. Many individuals died without legitimate issue, particularly in the 17th century. They left their wealth to friends and neighbors. If they designated no heirs and no natural heirs could be found, landed property might return to the crown. That was called escheat. Men and women were frequently widowed and chose to remarry. So step families were probably more common among the colonial population than at any time before the late 20th century. Now, there was some racial fluidity in the earlier settlement period. Indentured servitude was the dominant labor source in the 17th century. And those laborers were mostly white. But there were also black servants, of course, and some Indian and black slaves. But their numbers were small until late in the century, when slavery finally outstripped white servitude. During that earlier period, there were many free people of color in the population, and because central authority was weak, the gender ratios, male to female, were out of kilter, and laws against miscegenation were late in coming. There was also a good bit of racial mingling in the lower ranks of society. When many Caucasians from colonial immigrant stock find they have mixed race ancestry, it often dates to that time period of the 17th century. So now it's time to stop and think about the records that we rely on for research in the 19th and 20th centuries. For each, we're going to have to ask ourselves, did they exist in the colonial era? If they do exist, how are they different from what we're used to? If they don't exist, are there any counterparts that we can use as substitutes? Starting with birth, marriage, and death. Most government-generated vital records are exclusively 20th century records. We don't find many apart from marriage records in the 19th century, so we're used to looking for substitutes for them. In the 17th and 18th centuries, we're not going to find civil records of birth, marriage, and death, especially birth and death outside of New England. It's exceedingly rare that we'll find common substitutes like Bible records, simply due to the prevalence of illiteracy at that time, and the long period of time that's intervened between then and now for those records to be destroyed or disappear. And tombstones are also rare, because carving skills and workable stones and expendable money to buy such things were very hard to come by in that sort of hardscrabble environment of the frontier. So what to do? We still need to know when people were born, married, and died. So the best substitutes are church records. I noted that the colonial population was largely unchurched, but there are exceptions, and some wonderful records do survive. Many have been published already. Baptisms or christenings are good substitutes for birth, and burials are good substitutes for deaths. Marriages are noted more often than any other vital record for this 1600s, 1700s time frame. The denominations that we expect to see records like this for include the Anglican Church or Episcopal Church, the Lutheran or Reformed Church among the German population, the Friends or the Quakers, and sometimes, but rarely, the Presbyterians. Just occasionally you'll see a Methodist minister keeping a little book in his itinerant baggage in which he records all of his marriages that he's performed in one community as he moves from one to another in the backcountry, but that's pretty rare. For deaths, changes in ownership of property can help us with males. Estate records or wills can help us estimate the date of death, but please realize that there are many places where estates were handled informally due to long distances separating remote areas from capitals and county seats. Depositions before court sometimes give the ages of deponents. A person's age, after all, is often relevant to their knowledge of some event that they are testifying about. Often these ages are inexact, but they can be some of the very best records we have as to when someone was born. Frequently, dates of birth and marriage must be estimated from the age of the eldest child a couple has. And typical ages for men and women at first marriage can help us to estimate the age of the parents. Frequently, death dates must be estimated or restricted to a range between a last mention in a public record and a first reference to the deceased property being in new hands or to a widow acting alone in public records. In many places, dower rights were inchoate in the colonial period. So if a man is selling property without his wife's consent, without her signature on the document, that may mean that she's already dead and he's just a widower at that point. For maiden names of women, we often have to rely on evidence of inheritance into the family from their distaff relatives, their female side relatives. Traceable property in that case would be land or named enslaved people. But the typical female inheritance was not anything so grand. It was a spinning wheel, maybe, or livestock, clothing, or a bed. In the absence of traceable inheritance, we have to pay attention to who our colonial male ancestors appear with in records and who they migrate with. Some of those people that are associating with them or that are moving with them from place to place are very likely to be their in-laws. Sometimes naming practices can clue us into the distaff family, like the Virginia propensity to use distaff line surnames as given names for elder sons. Finally, autosomal DNA can help in some instances, particularly from the mid-18th century forward, but maybe even as far back as 1700 or so. We may have very little unique and significant DNA from most of our 18th century ancestors, but for certain individuals, you can count on having enough from them. The question is, which ones? Only testing and intensive exploration of your results will reveal where these opportunities lie, but they are there for each of us. As for divorce, it was more or less unheard of during the colonial period. What about census records? Well, wouldn't we just die for something like that in colonial times? A decennial census would be a godsend. Instead of, we have to have tax lists and lists of tithables form a substitute for that. The number and frequency of these surviving records vary from place to place. Although they were taken annually, they don't usually survive for every single year, and often they're very, very rare for a particular locality. And also their information value can vary quite a bit from place to place or time to time period. But they can be quite helpful. Colonial taxation was not on land. It was on people or labor. The most regressive form of taxation, if you ask me. Typically, all white males over a certain age were taxable, and that minimum age was often 16. Exemptions were granted for infirmity, and men over 60 often got exemptions for the rest of their lives upon petitioning the court. All persons of color over a certain age, whether they were male or female, were taxable, including enslaved people. So sometimes age can be estimated from first appearance of a young man or from the year an exemption is granted for an older one. Sometimes young men are listed with fathers and their masters by names, if they're an apprentice or enslaved people. Sometimes slaves are listed by name in tithables lists, and that's a great resource. If the run of tax list is relatively complete, this is also a good way for figuring out when persons first arrived in a location and when they left or when they died. Another good source for adult white male inhabitants of a locality are lists of militiamen and voters, or the signatory lists on petitions to the legislature or the governor. Many of these exist in state archives around the country. They're woefully underused. Proximity of persons to one another in a petition can indicate relationship because copies were frequently circulated for signing at gathering spots within a county. Subjects of a petition vary. They can be about problems with local officials, county formation, land tenure, security threats on the frontier, the siting of a courthouse town, clemency for a fellow citizen, the rights of a religious community, almost anything. Always consult published colonial records series for petitions, but transcriptions never replace the originals because of the trouble that people have in reading signatures accurately. And many petitions of less historical importance would just have been omitted from those printed compilations. You have to look at the original petitions methodically to find them. Probate records. Well, lots of those do survive in colonial times, wills and estates. That can be very helpful. Colonial testators tend to tell us more about their extended families than later ones, when the nuclear family became more important. It was standard to leave small tokens to more distant relatives at the time and to designate backup heirs or residuary legatees, as they're called, in case closer kin died without heirs of their own. And you know that people died much more frequently at earlier ages than they do in later generations. Remember that primogeniture prevailed in most places, which means that elder sons and elder brothers and their eldest sons tended to inherit when there was no will at all, rather. A testator, in fact, did not even have to mention his eldest son in his will for that son to inherit the balance of the land not mentioned. While land would go to the oldest male, personal property, like enslaved people, might be divided equally among all the children, except in Virginia after 1712, when enslaved people were treated the same as land in intestate estates. And so all the land and all the enslaved people would go to the eldest son or the oldest brother or the oldest nephew through that oldest brother if he were deceased. Remember also that many wills and estates were kept in statewide registries instead of by county. That includes colonies like North and South Carolina, Maryland, and New Jersey. Even New York, I think. In frontier environments, there might be little indication of an estate record. The land might simply pass to the eldest son, while the personal property got divided casually by agreement and with no record at all being made. A chance mention of a change in land ownership in a deed might be the only indication that the older generation has passed on. In general, family groups have to be inferred by associations with the father and the oldest son, rather than through an explicit list of children. Court records. Please don't neglect those. If they survive, make full use of them. Courts were not just judicial bodies in the colonial period. They handled county administration and oversaw citizens in their civic duties. They handled probate matters and kept roads in repair. They apprenticed poor children and punished women for having children out of wedlock. They mediated disputes between citizens and recorded cattle marks. They licensed merchants and tavern keepers and permitted folks to build mills and bridges and operate ferries. The list goes on, particularly if the loose papers of the court survive for the period that you're researching. By all means, go beyond the minutes or the orders of the court, that is, its summary proceedings, and check out the detailed papers accumulated by the court. You may find many interesting facts and many names not included in the minutes, including depositions, summons of witnesses, petitions and complaints, promissory notes, answers to defendants. Think also about the higher courts in the colony who heard appeals or oversaw any very serious matter like a felony or large debts, not just the local court. Note all the associations of your ancestors. Who are they doing business with? Whose obligations are they guaranteeing? Who are they testifying for? Some of these folks are their kin, and you can count on that. Unfortunately, such records aren't indexed, but that shouldn't stop you. Now about immigration records. Oh, how we would love to have immigration records for everyone traveling to and from England, Wales, Scotland, or Ireland to America in the 1600s and the 1700s. And in fact, there were laws which would, if enforced, have resulted in complete record. Sadly, they were not enforced. Customs officials kept good records of dutiable goods traveling abroad and the merchants who controlled them, but not of people moving from place to place. So with limited exceptions, some servants and transported prisoners, for example, we should not expect passenger lists for anyone moving through the British colonial world in those centuries. There was absolutely no naturalization aside from those coming directly from continental Europe, because allegiance did not change for most immigrants. The British monarch was already their sovereign. Usually the first mention that we have of an immigrant to these shores is his first acquisition of land or his first appearance in a tax list. Perhaps it would be a headright in Virginia, Maryland, or North Carolina. And then land grants or deeds. Above all other types of records, these are the staples of colonial research. That's why I am ending with them. Land deeds might be recorded on a colony-wide level, as in South Carolina or New Jersey. Actually, it was divided into East Jersey and West Jersey for this purpose. Some grants will be issued not by the state government at all, but by a proprietor working out of his own land office, like Lord Granville in North Carolina. A grant is often the first record documenting someone's presence in an area. The chain bearers are also important on the survey attached to the grant, as they are neighbors. The witnesses on deeds are equally crucial. Often the first time a young man will appear in any county record will be as a witness to a relative's or a neighbor's land transaction, or as a chainer on a land grant, helping to stretch the chain that measured the metes and bounds of the grant. That could be an indicator that he has just come of age, and of course, the buying and selling of land is crucial to knowing when a person arrived in a place and when he left. If you cannot establish a timeline, you will not be able to verify a plausible migration from one place to another. After all, a person cannot be in two places at once, and we know migration was frequent in the time period we're studying for the many reasons that we mentioned earlier. So now in this second half of our presentation, let's move on to a real-world example. One of my biggest success stories to date is with the family of Captain John Lightfoot. He was born before 1755, and we know that from the 1800 census, and he died about 1824 in Stewart County, Tennessee. John was a Revolutionary War soldier entitled to bounty land for service in North Carolina. He lived in Montgomery County while he was in this state, very close to the east bank of the Yadkin River, north of Mount Gilead, and south of Uwharrie National Forest, near the crossroads of PD. Even though this county is missing most of its records before 1843, from a tax list that did survive at the state level in 1782 and the land entry of 1780, we know he was there from the very beginning. But not much earlier, for he doesn't figure in Anson County, which is the county from which Montgomery was formed in 1779. Also, we know that he had a slave named Violet, because she is enumerated in the 1782 tax list. Now, this seems to have been his only enslaved person. She was called Granny Violet in his estate file in Stewart County, Tennessee, because she bought property at the estate sale there. So she was with the family from at least 1782 until his death. He also mentions that care should be given her in his will, and that so we can assume that she was allowed to have some money of her own. I suspect she raised his children and was beloved by the family. For his first wife, Elizabeth, died relatively young, and he married again to Eleanor Cathy, a widow, only after he arrived in Tennessee sometime between 1800 and 1810. He received 2 land grants in Montgomery County, one in 1780, the second in 1795, and bounty land for his military service in Tennessee, which he sold without claiming it, as so many Revolutionary War soldiers did. So a few stray surviving records show that he was a militia captain in Montgomery County. His second land grant in 1795 calls him John Lightfoot, Esquire, which suggests that in addition to service as captain of militia, he was also a justice of the peace in Montgomery County. Additionally, someone named Henry Lightfoot apparently served in a company headed by Mark Allen to patrol Little and Deep River for Tories during the Revolution. This company was raised in Montgomery County, so the suggestion is that this Henry was potentially an associate and probably related to John Lightfoot. This Henry Lightfoot could not be John's son Henry, much too young to be the son Henry is much too young to be this Henry active during the Revolution. So he's probably the same person as a lawyer who was active in the 1780s in many Piedmont courthouse towns and later served briefly as a state senator. He lived in Moore County and was bitterly opposed to Philip Alston of House and the Horseshoe fame over a legislative election controversy. Henry Lightfoot's obituary appears in early newspapers in 1789, so he was an esteemed member of the legal and governing class. One of John Lightfoot's daughters, Temperance, was married to my ancestor Edmund de Berry. The groom's father, Henry de Berry, was the first sheriff of Montgomery County. And Edmund later was a state legislator and a congressman from this area. Of all the children of Captain John Lightfoot, Temperance de Berry was the only one to remain in North Carolina. The rest accompanied their father to Tennessee. In John's case, we are very lucky to have his Bible record, a transcript of which is illustrated here on the left. It was published in one of the old Virginia genealogical magazines. It shows that his first wife was named Elizabeth and that they had a number of children together. It's written in a book called The Saints' Everlasting Rest, not in a Bible. Now, that was a popular and an influential devotional text written by a Puritan named Richard Baxter in 1650. You'll see that there's no maiden name for Elizabeth in this record and no marriage date, only a list of children. In addition to Temperance, their names were Wilson Lightfoot, John Lightfoot, Thomas Lightfoot, James and Henry Lightfoot for the boys, and Sally and Polly for the girls. We could divine from the age of the eldest child that John and Elizabeth would have been married, say in the mid to late 1770s, just about the time he first appears in North Carolina. By the way, this record was published in one of 3 Virginia magazines of the early 20th century, when their focus was primarily genealogy. The person who owned the Bible at that time was one Maud Reagan, who was descended from the daughter Polly Lightfoot Johnson. So it's a good idea, if you're looking at old Virginia families, to check Swim's index for anything that might have been published in the Virginia Magazine of History and Biography, or Tyler's Quarterly, or the William and Mary Quarterly, on people that you're interested in. Similar magazines and journals exist for Virginia and other states that are particularly useful for the entire colonial period. So let's summarize what we know about John Lightfoot already. We know that he was born, say, from 1745 to 1755, given the age of his first child and the 1800 census, which puts him over 45 years of age. We know the names of his first wife, Elizabeth, and his children, Wilson, John, Henry, James, Thomas, Temperance, Polly, and Sally, and we are lucky to know them in their birth order as well. We know that he had a single slave named Violet when he entered the county, and he never seems to have owned more, except for those that came to him through Eleanor Cathy, and they were not his. She was still in his family at his death, as we noted. We know that he was likely from Virginia, since that is the family tradition, and it is a prominent location for early Lightfoots. Not that there weren't Lightfoots in other places, but there are a lot of Lightfoots in Virginia in the colonial period, as opposed to some of the other places where they appear, like coastal North Carolina or Pennsylvania. His first appearance in North Carolina was around 1780. And we know that though he was not rich, he was a man of reasonable social prominence. He was literate. We can tell that from his signature, and also the fact that he was listed as a squire in one of the documents we have, and he was a captain of militia. We know that he may have been a contemporary of similar age and probably closely related to someone called Henry Lightfoot. So where to go next? Where was John before 1780? In searching for his origins, think about typical migration routes for people who lived in the Pee Dee section of North Carolina. Many of them came down from Maryland or Virginia, particularly Southside Virginia. Some came from eastern North Carolina. Does John fit into any of these categories? The 1790 and 1800 censuses reveal very few Lightfoots elsewhere in North Carolina. There's a man named Bartholomew Lightfoot, born in the 1770s, who settled in Chatham County, North Carolina, and became very prosperous there. His mother and his stepfather brought him from Wayne County to Wake County. He became a sheriff and a magistrate in Chatham. There was another set of Lightfoots in Northampton County, North Carolina, in the far northeastern part of the state. That was headed by a William Lightfoot, and he has ties to Brunswick County, Virginia. We know who his father was. Northampton County was the place of origin for the DeBerry family, into which John Lightfoot's daughter Temperance married, and it would be a natural migration route down the central coastal plain to the Pee Dee, but there's no evidence of John's earlier presence there. Now, I could check for Lightfoots in early North Carolina by looking at compilations of tax lists, colonial land grants and land entries, and the index to the North Carolina Genealogical Society Journal, which is on their website. And also I could check the index to state and colonial records of North Carolina, which is a multi-volume, over 20 volumes worth of documents from the colonial period into the early independence period that was published in the early to mid 20th century. And there are several other good sources to keep in mind, like the Secretary of State wills that have all been abstracted, which cover all the colony, especially in the early 18th century and the 17th century, or Hathaway's Register, which focuses on northeastern North Carolina, where we had our first settlement. So a spot check of records in counties where Lightfoots appeared was part of my research strategy, but these searches were in fact dead ends. Many believed that John came from Virginia, and my next thought was to look for Lightfoot families in Virginia, in which the given names Henry, Thomas, and John were commonplace. I also couldn't shake the idea that the name Wilson, used for John's oldest son, had a particular significance. I suspected that John's mother or his wife was a Wilson or somehow connected to Wilsons, and that he honored that family in the naming of his own children. So in order to find places where Lightfoots lived in colonial Virginia, I utilized Torrance's Index to Virginia Wills and Administrations, which covers every will and administration known to have been filed up through 1800. So immediately, Brunswick County and Isle of Wight County caught my eye because people named Henry Lightfoot died there in the 18th century. I determined that the Henry Lightfoot who died in Brunswick County was not my man. He was actually the ancestor of the Northampton County William Lightfoot. The Henry Lightfoot who died in Isle of Wight County, Virginia, was a different matter. His estate record was dated about 1754, and it listed a handful of slaves and a surviving group of children who were named as Patience, Mary, Henry, Bartholomew, and Thomas. Now, 3 of the names there matched my John's family, and I could also determine that his wife was likely named Patience, and that he actually died in 1748 or 49 because his oldest son, Bartholomew, had already inherited his land by that date, as the deeds clearly indicate. This happened quietly and without much notice in the records because Henry died without a will, and the eldest son automatically inherited all of his land and enslaved people per the laws that pertain to intestate estates in Virginia at that time, as I was explaining earlier. The estate wasn't settled until 5 years later, and I had to ask the question, why? Why was it settled specifically in 1754 when he probably died 5 to 6 years before that? Now, there were 2 inventories filed for this Henry Lightfoot in 1754. At least this is what I thought. One listed enslaved people, the other listed some personal property, including some fancy furniture that one might associate with an office or business. But looking at the index of the will book, that is the handwritten index in the book itself, not the Torrance index that's printed on the right, I discovered that one of the inventories, the one with the slaves, was indexed as Henry Lightfoot Sr., and the other one, the same year, was listed as Henry Lightfoot Jr. in the index. This is the only indicator that we're dealing with 2 people. I suddenly realized that the father died first, and then the son, and it's probably the son's death that prompted the final estate settlement of the father. By looking at wills and administrations in the county, I could account for the eldest son, Bartholomew, right up until his death. He was ancestral to the Lightfoots mentioned earlier who settled in Chatham County, North Carolina, and some who remained in Isle of Wight. He built a little Dutch-style dormered house called Six Oaks, which still survives. Another son, Thomas Lightfoot, married Joshua Jordan's widow, Sarah. His mother, Patience Lightfoot, Henry Sr.'s widow, was involved in securing his administration on the estate of his wife's first husband. It appears he got into some trouble for the way that he handled her property. He quickly disappears from the record of Isle of Wight and he probably either died without issue or moved elsewhere. In studying the wills and estates and deeds, however, I soon came across another Lightfoot wife. And at first, I didn't know what son she married, but since there was only one Lightfoot family in the county, it had to be one of them, and I knew that her husband died very early in their marriage. Her name was Honor Pierce, and she was the daughter of Honor Goodrich, who first married James Wilson and secondly married Jeremiah Pierce. So Honor Pierce had a number of older half-siblings, brothers, named Wilson. And the deeds and the wills and estate records make clear that Honor was first married to a Lightfoot. Then she moved to nearby Brunswick County, Virginia, and remarried to someone named John Sims. Now, these are key facts. You must probably remember that John Lightfoot of Montgomery County, North Carolina, named one of his oldest sons Wilson Lightfoot. So if Honor Pierce was his mother, that would make sense, because his grandmother, Honor Goodrich, married into the Wilson family, and he would have had a number of half-uncles named Wilson. Those Wilson uncles might have taken a lot of responsibility for their nephew, considering how soon he was orphaned. I felt as though I was on the right track. And that was confirmed when I took a look at the will of John Sims, who died in Brunswick County in the 1770s. He is the one who remarried Honor Pierce Lightfoot. And he leaves a small bequest of livestock to John Lightfoot and mentions his wife Honor Sims, and that is indeed Honor Pierce Lightfoot Sims, the mother of John Lightfoot. In fact, in rummaging around through Brunswick County wills, I was able to prove that John Lightfoot of Montgomery County was present in the county of Brunswick, and that he married his first wife Elizabeth there. My first lucky find was an unrecorded will which was published originally in the Southside Virginian, which is now completely digital and online, and you can look at it at will. And this was the will of Anne Allen, of all people, the wife of Thomas Allen. She died around 1783. Now, it's an unrecorded will because the court set it aside, and probably because it was invalid for some reason, that she couldn't actually have exercise authority over the property that she was bequeathing, or maybe she was violating some terms of her dower or something of that nature. So it was never recorded and never had the force of a recorded will, which had to be carried out. And probably Thomas Allen had something to do with it being overturned as well. Now, Anne died around 1783, and her will was totally set aside. She names her son Colby Randall, her daughter Susanna Jackson, so it's apparent that she had previously been married to a Randall male. One of her daughters was named by her as Elizabeth Lightfoot, but no husband was mentioned. Of course, that caught my attention. So now that I had Anne's children, I could look at previous wills and estates in Brunswick County to find out who her first husband was. The names of her children matched perfectly with those of William Randall, who died about 1771. He left a will that you see abstracted on the right. It too mentions Colby Randall as a son, Susanna Jackson, and a daughter, Elizabeth, but it gives no married name for Elizabeth because at this point she wasn't married. The key point was that he left her an enslaved girl named Violet. Now that was key, because that's clearly Granny Violet, whom we know from the tax list, we know from the will and the sale of the estate of John Lightfoot in Stewart County, Tennessee. So now I knew to my satisfaction that John Lightfoot of Montgomery County, North Carolina, began his married life in Brunswick County, Virginia, and married Elizabeth Randall there. He was almost certainly the son of Honor Sims, the stepson of John Sims, mentioned in the latter will, and Honor then connects him back to the Pierce, Goodrich, and Wilson families of Isle of Wight County, Virginia. Now, one of the key points in this research sequence is the importance of widows, remarriage, and step-family arrangements in this period of time in the colonial period. Life was nasty, brutish, and short for many people. Men and women could be married multiple times as former spouses died. The women are often connectors from one family to another. If they survived multiple husbands, it could give them some power to manage their own affairs and acquire their own property. Many of them created legal mechanisms to secure property to their children from a prior marriage when they remarried, either by conveying the property first, creating prenuptial contracts, or appointing trustees to take care of the property that they brought into the marriage, apart from the husband. Anne Randall Allen is an example on one side of this family, though her will was overturned probably because of her second husband's interests and conflicts with her first husband's will. Honor Goodrich Wilson Pierce and Honor Pierce Lightfoot Sims, mother and daughter, are examples on the other side. And by the way, the Pierce family is a connection to Pocahontas, at least the family of John Rolfe's third and final wife, the daughter of Captain William Pierce, who raised Pocahontas's children at Mulberry Island on the James. Jeremiah Pierce was descended from Captain William Pierce. So, which son of Henry Lightfoot Sr. and his wife Patience did Honor Pierce marry? Well, almost by process of elimination, it has to be Henry Lightfoot Jr., who we know was dead by 1754. We know what happened to Bartholomew. We know who Thomas married. So that only leaves one person. That leaves Henry Jr. And this comports well with the chronology that we have for John Lightfoot's birth. It had to be between, say, 1745 and 1755. And in fact, there is a deed in Isle of Wight records from Bartholomew Lightfoot, the eldest son of Henry Sr., to John Lightfoot in 1755 for a small tract of land. It was a deed of gift for love and natural affection, in the terms of the day, to his cousin, he says, John Lightfoot. He says actually for love and natural affection and for a promise made to his deceased father, Henry. Now, the pronouns are confusing, but I think what this implies is that Bartholomew promised his brother Henry Lightfoot Jr. that he would make some provision for Henry Jr.'s eldest son, John, on Henry's deathbed. And so he did. And John Lightfoot sold this land in the 1770s. What about the word cousin? Well, people in the colonial period used English terms for kinship a bit differently than we do today. Cousin, in some of these older documents, usually means a niece or a nephew. Cousin German is a literal first cousin, but just cousin is often a niece or nephew. Brother could be brother-in-law, as well as actually a brother. The name for mother or father or sister, same thing for that. If they're called, a mother, it could be a stepmother. Or a father could be a stepfather, or the father of your wife could be called your father. Brother-in-law is almost always a stepbrother. Son-in-law can mean a stepson. I've heard that nephew and niece can mean grandchild, and I have seen an example of that, but it's much earlier than the 1700s. I think that's more of an archaic meaning for that those terms that you don't frequently see in the 1700s, but you may see it in the 1600s or the 1500s or before that. What happened here illustrates the importance of primogeniture in the society. Both Henry Lightfoot Sr. and Henry Lightfoot Jr. died without a will. Without a contrary provision from such a will, all the land went to the eldest son, Bartholomew. He was quite a prosperous fellow, in a position to build a manor house like the one you see here, Six Oaks. The younger sons would have to move on unless the oldest son was magnanimous, as in this case, and gave something to the cadet lines. As for John's probable brother named Henry, he appears not at all in Virginia records, but he would have been quite young when he left, and as a younger brother and the younger son of a younger son, he would have been less likely to receive traceable property. But we do have a narrative account from an old letter which suggests that such a brother existed, and also that John Lightfoot came to North Carolina with several of his wife Elizabeth Randall's siblings and first cousins. The land grants, tax lists, and petitions surviving from old Montgomery County bear this out. In fact, when John Lightfoot went on to Stewart County, Tennessee, A number of the Randalls joined him there as well. Another key point, families traveled together and spread the risk in the 18th century of migration and before, just as they would do later in the 19th century. When you believe your ancestor made a move from one place to another, check to see if others made the same move 5 years on either side. If they did, there's a strong chance that your theory of migration is correct and that the whole crew is connected somehow. So now we have our next two generations. We have Henry Lightfoot Sr., who married Honor Pierce and died about 1754. And we have Henry Lightfoot Sr., who married Patience and died about 1748 or 1749. Now, Patience, I have since discovered, was probably the daughter of Thomas Ward and his wife Mary. I can't explain it adequately because I have little time, but we do have a deed from the first decade of the 18th century in which James Chapman and his wife Frances sold half of a small tract of land that they had inherited from Thomas Ward. The deed mentions that Thomas was Frances's father, and that she had a sister named Patience, to whom the remainder of the tract was reserved. Note that in the absence of any sons, land was inherited by daughters equally when a person died without a will or intestate. There's no record of when the second part of the property was sold. Many deeds went unrecorded in this period, just as they did in later periods. Thus, this deed, on its own, would not be nearly enough to prove that Henry Lightfoot Sr.'s wife was Patience Ward. There are many girls named Patience in old Isle of Wight County. It seemed to be a favorite name for girls in that era, but an important record made a connection. It's a fragmentary transcription of an ancient Bible that was kept in the Chapman family called the Breeches Bible. The Bible was so old and worn that many entries could not be read by the owner early in the 20th century when they did this transcription. No one knows where the Bible is now. Through imaging techniques that we have today and enhancement, we might be able to get a good, complete record from it. But the legible entries show that one of the children of James Chapman and Frances Ward had as a christening sponsor none other than Henry Lightfoot. Mary Ward, who had since remarried to William Clark after her first husband Thomas Ward died, is also among the sponsors, as well as some of the Chapman kin. That's a key point. Sponsors at a baptism were often relatives in this period. James Chapman's father, Charles Chapman, was clerk of the county court of Isle of Wight County late in the 1600s, and Henry Lightfoot Sr. would be his successor, in fact, starting in the early 1700s, going on until 1729. So Henry Sr. was also a militia officer and a vestryman of the Newport Anglican Parish in Isle of Wight County. We've talked about how influential and wealthy colonial families created powerful kinship networks and transmitted authority from one generation to the next. Finally, Bartholomew Lightfoot, the eldest son of Henry Sr., mentions two illegitimate daughters in his will, and they were Frances and Patience Wills, the same given names held by the Ward sisters, who were probably his mother and aunt. My confidence level in this conclusion is high, even though I have no concrete proof. And in fact, if you hope to find the identities of your colonial female ancestors in the absence of marriage or probate records, you too will be looking for this sort of fragmentary evidence and try to piece it together. If the two daughters hadn't been heirs of their father, this would have been even harder. And I also want to add to that there's one even further little piece of evidence to bring the Wards and the Lightfoots and the Chapmans together, and that is when Bartholomew Lightfoot, the eldest son of Henry and Patience Lightfoot, died. Guardians were appointed and chosen for his legitimate and illegitimate children, and one of those was none other than James Chapman, who was in that Bible for Frances Ward and John Chapman, and for whom Henry Lightfoot, in fact, was the sponsor at his baptism. So there's another family connection where a cousin is probably taking charge of Bartholomew Lightfoot's children and their affairs when he died. That's the power of the extended kinship group at work in the
18th century and the 17th century. Even more powerful maybe than and complicated than what you see in the 19th century. And we've fallen far from that today. But what about Henry Lightfoot Sr.? Now, I've stated that he had several offices that he held locally. His land ownership was rather unimpressive, but we do know that he was extremely literate. He was the clerk of court for nearly 20 years, from 1710 to 1729. This was no small thing in colonial Virginia. He made a respectable marriage. Where did he come from? He was in Isle of Wight from about 1710, but not previously to that. There are no older Lightfoots in the county. He must have come from somewhere else. When we look more broadly across Virginia, we do come upon earlier records of him. For instance, he was involved in a 1705 land speculation with a number of other investors, and he received a large land grant with them in Northern Virginia. This was 6,500 acres, and it earlier escheated to the Crown. I make a point of investigating each of the other individuals involved in that deal. They were all inhabitants of James City, Charles City, and York counties, the very heart of power in 17th century Virginia. They were all influential men. One of them, David Bray, is buried in Bruton Churchyard in James City County. One of them was an acting attorney general for the colony at one point. We see Henry in several court cases in York County, Virginia, from 1704 to 1710 before he went to Isle of Wight. Some of these associates with him were his partners in the land deal, those associated with the court records, and a couple of them associate him remotely with two men of great prominence in the colony early on, John and Philip Lightfoot. Now, these fellows were tax collectors, justices of the peace, and militia leaders. Philip was a ship's captain early in his career, and he later made a fortune as a merchant. He married Alice Corbin, the daughter of Henry Corbin, a very prominent early Virginian from Middlesex County with a noble pedigree. I'm sorry, it was actually Lancaster County. Philip's son of the same name became so wealthy that he was known as the Merchant Prince of Yorktown. That was one of the most prosperous families in the colony. John, who was Philip's nephew, was the son of another ship's captain named John Lightfoot, who was Philip's eldest brother, who had once been named auditor of the colony and then removed from that office by the king at the petition of several of his colleagues who didn't think he was competent enough in his own finances to occupy that position. The senior John Lightfoot had been an Inns of Court trained lawyer in London, but became a mariner during the Commonwealth period, probably because of the English Civil War and his allegiance to the king. His son, the younger John, sat on the governor's council late in the 17th century into the early 18th century, and he was the escheator of the colony for a time, working in the land grant office with land that would reverted to the crown through lack of compliance with the terms of the grant or lack of heirs. He married the daughter of Colonel Thomas Goodrich, who was a leader in Bacon's Rebellion of the 1670s. Now, it made perfect sense to me that Henry could have been the son of either of these men, the uncle Philip Lightfoot of Teddington, or the nephew John Lightfoot, the counselor. Early in his life, Henry Lightfoot resided in the same county where Philip's descendants were prominent, which is York County. He had the same first name as Philip's father-in-law, Henry Corbin. On the other hand, he received a huge land grant that John Lightfoot, the counselor and escheator, could have helped him acquire. Also, he became clerk of court at an early age by the governor's appointment. He had to have friends in government to get such an appointment. His parents must have been able to afford a good education for him through private tutors, or he could not have carried out the duties of the office. There was no headright issued on him, so it seemed more likely that he was someone born in the colony than that he entered it as an adult. The problem is, no will survives for either John Lightfoot or Philip Lightfoot. Though each probably had a will, they both lived in counties where records were destroyed in the Civil War. That is the American Civil War. Philip lived in Gloucester and Charles City counties, and John lived in King and Queen and New Kent counties, a little bit further to the north. Now, I found two more mentions of Henry Lightfoot that were published in the old William and Mary Quarterly. I located them through Swim's Virginia Index. One was a letter written by Mungo Inglis, who was a grammar and rhetoric master at William and Mary College, and it was written to former Governor Francis Nicholson in England. The land grant was given under Governor Nicholson. By the way, Mungo's son succeeded Henry Lightfoot as the clerk of Isle of Wight Court. So Mungo's wife was the sister of Colonel David Bray, one of Henry Lightfoot's partners in the land speculation. So it's all coming together in a way. Nicholson had recently left the colony after a great deal of friction with many of the local bigwigs. Inglis was conveying all the gossip about a night late in 1705 when the College of William and Mary at Williamsburg burned to the ground. This was very soon after the foundation of the institution. That night, it was being used to house the members of the House of Burgesses and the Governor's Council, who were attending public business the next day. Inglis describes how the fire was first sighted, how the alarms were raised, and how people started scrambling to exit the building and save their property. His letter and a bit of additional testimony about the fire each mention Henry Lightfoot. Inglis calls him Harry Lightfoot, and Harry is a common nickname for Henry of the time. From Inglis, when by Mr. Wheatley's noise, Mr. Thacker and Harry Lightfoot, who lay at the south end of the building, were affrighted and got up so soon as Mr. Thacker opened the door, where Mr. Secretary's office was formerly kept, the lead of the melted gutter dropped upon his clothes. So Harry Lightfoot was sleeping in the south end of the building in the same area, perhaps in the same room, as Chichley Corbin Thacker, the Mr. Thacker referenced here. It's worthy of note that Thacker was a nephew of Philip Lightfoot's wife, Alice Corbin. Note that he was simply called Harry Lightfoot, not Mr. Lightfoot, like the others. That probably indicates that he was quite young in October of 1705, maybe just coming to manhood or slightly younger, a teenager. It was also a familiar, intimate version of his name, suggesting that he was well known to Inglis. The other reference about that night and Henry comes from Colonel Edward Hill III, who was also sleeping in the building that night. Hill was lying in the chamber of the Speaker of the House of Burgesses at that time, Benjamin Harrison, yes, an ancestor of the two Harrisons who were presidents of the United States. He later gave testimony about the exit from the building and noted that he'd seen Mr. Henry Lightfoot loitering about and called him over to assist in moving his trunk away from the structure. So he knew Henry by sight, and he even refers to him as Mr., a term of respect that Colonel Hill was one of the wealthiest men in the colony, and his father had been one of the most powerful in the circle of Governor William Barclay. That use of the word Mr., the term Mr. as a term of respect for Henry Lightfoot is meaningful. Colonel Hill owned Shirley Plantation on the James, which later fell into the hands of the Carter family. In fact, he had a connection to the Lightfoots. His father, Colonel Edward Hill II, had taken the widow of Thomas Goodrich, Anne, as a second wife, and Anne was mother to John Lightfoot's wife, also named Anne. So it's even possible that Colonel Edward Hill III was Anne's child and a half-sibling to John Lightfoot's wife, that is, the counselor John Lightfoot. The overall suggestion is that Henry Lightfoot moved in circles of power and was known to people who were prominent. And likely both of his possible fathers, either John Lightfoot or his uncle Philip, were also moving in these circles, so it makes sense. He was known to their kin. He operated in York County, in which each of them had interests, and received a large land grant in King and Queen and Essex counties, where one of them, John, had considerable property of his own. It's almost a certainty that one of them was his father. But is there any way to prove which one? There was one bit of hope here, and that is Philip Lightfoot's family graveyard is still extant. at Teddington near Sandy Point in Charles City County. Now, the family was wealthy enough to have tombstones imported from abroad in the 17th and 18th centuries. The graveyard was once decayed and ransacked, but it's now been restored. The inscriptions were first read in the early 20th century, and we also have a record related to the estate settlement of the elder Philip Lightfoot, heard by the General Court, the highest court in the colony, in May of 1740. We don't have case papers, only a digest made from the notes of a lawyer. But the case explains that the eldest surviving son of Philip Sr. was Francis Lightfoot. And from his tombstone in this graveyard, we know that he died the 7th of January, 1727, in the 41st year of his age, so born about 1687. His next oldest brother, Philip Jr., the merchant prince I referred to earlier, was born in 1689. We know that Henry Lightfoot was active as an adult in court cases as early as 1704, so he must have been at least 21 at that time. So he was born in 1783 or 1683 or before. That suggests to me that he had to be a son of John Lightfoot. In fact, couldn't be a son of John Philip, so he's most likely a son of John. In fact, John had a documented son named Thomas, who named his own son Henry, the one who later settled in Brunswick County, Virginia, and was ancestral to the Northampton County Lightfoots in North Carolina. So all in all, it's very likely that Henry Lightfoot, my Henry of Isle of Wight, was John Lightfoot's son. We can prove that John Lightfoot was married to Anne Goodrich by at least 1681, so they were married in time to have him, and he named some children, Thomas and Henry, that resonate with John Lightfoot's family. John Lightfoot had a definite son named Thomas, grandson named Henry, through that son Thomas, and his father-in-law, Thomas Goodrich, had the given name Thomas. Now, tracing John and Philip Lightfoot back to England is also a relatively simple matter, merely because they were so prominent. Also, Philip's tombstone not only displays his coat of arms, but it gives his father's and his grandfather's names, although it does garble things a little bit. What really clarifies the lineage is a 1683 Herald's Visitation of the City of London that was recently published by the Harleian Society, in which Philip's brother William Lightfoot, a lawyer, was questioned in England about his right to an armorial bearing and his relations and ancestors. His pedigree report mentions that he had a brother named John who died beyond the seas, and that's the captain, the father of John Lightfoot of New Kent County, Virginia, the counselor, and a brother Philip who was currently living in Virginia, and that's the Philip Lightfoot of Teddington associated with that graveyard. Other records in the Prerogative Court of Canterbury clarify John's line because John had interests in both England and America, and the Prerogative Court of Canterbury handled estates that overlapped like that between the two continents. Two sons of Captain John were said to be living in America in this record. Strangely, the Herald's report states that the captain died without issue, which is what sine prole means. The Prerogative Court of Canterbury administration states that there were two sons living beyond the seas, Philip and John. Information for both statements was given by the same man, William Lightfoot, their uncle, in the same year. My guess is that William did not want to admit to the Herald that his eldest brother John had sons living. If he did, his brother Francis's sons in England would have been required to add a difference to their arms as offspring of a cadet line. The eldest surviving son of the captain in Virginia would have had a claim to undifferentiated arms as a senior line in the family. And if you look back to the paternal grandfather of John, William, and Philip, the Reverend Richard Lightfoot of Stoke Brueren in Northamptonshire, you'll see that he married an Aske, A-S-K-E, that's the surname, the daughter of a goldsmith, Robert Aske of London. Richard's memorial inscription in his parish church shows his arms, that is his coat of arms, impaled, which is the same coat of arms that appears on Philip Lightfoot of Teddington's tomb without the impalement. An impaled coat of arms is a shield divided in half. So one side we have the Lightfoot arms that appear in Virginia, and on the other side we have those of his wife, the Aske family. It confirms this. And the Aske pedigrees from Yorkshire show that the goldsmith into whose family Reverend Richard Lightfoot married was the illegitimate son of an heir of a gentry family, the Askes of Auden. Robert was apparently acknowledged by his father, Robert Aske of Auden. His mother was apparently a daughter of another important goldsmithing family, the Lindsays, and as an important person in London who served in several prestigious offices, both within the Guild of Goldsmiths and the corporation of the city, including as keeper of London Bridge, by the way, Robert Aske, the goldsmith, was allowed to bear his father's arms. These Askes include the leader of the Pilgrimage of Grace, a pro-Catholic march against Henry VIII, who was trying to separate from the Catholic Church. And this family is also descended from the Plantagenet dynasty in several different ways. They were also ancestral to the Fairfaxes of Virginia, who were proprietors of the northern neck of Virginia and held huge estates there. So in later generations, these descendants would be very prominent in Virginia's history and connected to George Washington, among others. And here's the Aske of Auden pedigree showing the link to Robert Aske, goldsmith of London, illegitimate though it may be, through a bastard line. Colonial research is both similar to and different from the kind of research that most people cut their teeth on. Some records recede into the background, while others take their place or become more prominent. Primogeniture and the legal invisibility of women are difficult barriers. It often becomes necessary to collect every instance of the surname in a given area and compile a careful chronology to get a good picture of the family. Inference from limited evidence is often a necessity. Nevertheless, I hope that this example has given you hope that these barriers are not insurmountable. Even far less prominent families who left even fewer records than the Lightfoots are ultimately traceable through colonial environments to the old world points of origin from which they came. And this is going to become even more so the case when we have greater access to complete visual indexing of handwriting that's taking place through one of the experiments at the Family Search website. And I encourage you to go in there and turn on that experiment, a full text search. Put in the surnames and the given names that you're looking for in various spellings, including abbreviations of the first name, and see how many instances you can come up with of people of a relatively unusual name in prior locations. That will help you trace back with less difficulty than we did maybe even 2 or 3 years ago, by looking up the chains of migration to places people primarily migrated from, and looking for naming patterns in various people finder sources like Torrance's Wills of Virginia or Swim's Index. You also now have this option to use that splendid tool, which is only going to get better with time, using artificial intelligence, Family Search's indexing project, using automated means to index images of records and recognizing handwriting. That's just amazing. We live in amazing times, and this research is going to become easier because of it.